It is officially happening. Google is being sued for violating antitrust laws, and the lawsuit is fascinating. Viva Frei, Montreal litigator turned YouTuber, and yes, it is finally happening. Google is being sued for violating American antitrust laws. Now, when I say the lawsuit is fascinating, the lawsuit is in fact fascinating, but it is 61 pages of tedious technical reading. So I'm going to do my best to break it down, simplify it so that it can be understood by lawyers and non-lawyers alike, but more specifically the non-lawyers. And in this particular case, we're fortunate enough to have something of an executive summary that was published by the Department of Justice, which effectively summarizes the entire 61-page lawsuit, except the executive summary itself is 8 pages of dense drafting. So Google is being sued for violating antitrust laws. What does it all mean? Well, we have to start with the act in virtue of which they are being sued, and it is called the Sherman Antitrust Act, I think. Yeah, it's called the Sherman Antitrust Act. See, that's what happens when you do your homework. The information just rolls off your tongue. And what is the Sherman Antitrust Act? You should be asking yourself, and if you're not asking yourself that question, you should be asking yourself why you're not asking yourself that question, because it is central to this vlog. The Sherman Antitrust Act of 1890 is a federal statute which prohibits activities that restrict interstate commerce and competition in the marketplace. The Sherman Act was amended by the Clayton Act in 1914. The Sherman Act is codified in 15 United States Code sections 1 to 38. And in order to make antitrust law as interesting and sexy as possible, I am going to yet again break out my sexy voice.
Broad and sweeping in scope, Section 1 of the Act states that, quote, every contract, combination, in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states, or with foreign nations, is declared to be illegal. End quote. Section 2 of the Act prohibits monopolization or attempts at monopolizing any aspect of interstate trade or commerce and makes the Act a felony. And I read the typo not for mockery but for full transparency.
I should probably lose my sexy voice now. That is a 30,000-foot overview of the Sherman Antitrust Act, and we are going to be focusing on Section 2 for the purposes of the Google lawsuit. Now, the most historic application of the Sherman Antitrust Act was a Supreme Court decision from 1911 breaking up Standard Oil on the basis that it constituted an illegal monopoly. The essence of the Sherman Antitrust Act is intended to protect consumers when a company has something of an illegal monopoly, which generally seems to be recognized at anywhere between 70 and 80% of the market share. These two elements, that is to say a monopolistic ownership of the market of anywhere between 70 and 80% and the detriment to the consumer, are going to be key elements in the Google lawsuit, but we will get there. But for now, we cannot possibly talk about the Google antitrust lawsuit without first discussing perhaps the most famous antitrust lawsuit of all time, the United States versus Microsoft 2001 decision. United States versus Microsoft Corporation was a noted American antitrust law case in which the US government accused Microsoft of illegally maintaining its monopoly position in the PC market, primarily through the legal and technical restrictions it put on the abilities of PC manufacturers and users to uninstall Internet Explorer and use other programs such as Netscape and Java. At trial, the district court ruled that Microsoft's actions constituted unlawful monopolization under Section 2 of the Sherman Antitrust Act of 1890, and the U.S. Court of Appeals for the D.C. Circuit affirmed most of the district court's judgments. The central issue in the Microsoft lawsuit was whether or not Microsoft was legally allowed to bundle its Internet Explorer with its Windows operating system. The trial judge in the Microsoft judgment, Judge Jackson, rendered his decision in 2 parts. He first issued a finding of fact, and then he issued conclusions of law. His conclusions of law ordered the breakup of Microsoft under the Antitrust Act, and although that portion of his decision was overturned in appeal, his finding of fact was not. Judge Thomas Penfield Jackson issued his findings of fact on November 5, 1999, which stated that Microsoft's dominance of the x86-based personal computer operating systems market constituted a monopoly, and that Microsoft had taken actions to crush threats to that monopoly, including Apple, Java, Netscape, Lotus Software, Real Networks, Linux, and others. Judgment was split in 2 parts. On April 3, 2000, he issued his conclusions of law, according to which Microsoft had committed monopolization, attempted monopolization, and tying in violation of Sections 1 and 2 of the Sherman Antitrust Act. Microsoft immediately appealed the decision. On June 7, 2000, the court ordered a breakup of Microsoft as its remedy. According to that judgment, Microsoft would have to be broken into 2 separate units, one to produce the operating system and one to produce other software components. The entire story of the Microsoft lawsuit lawsuit is a video unto itself. Suffice to say that Microsoft appealed the decision, the parties ultimately settled such that Microsoft was never actually broken up, and whether or not Microsoft respected the settlement, it's a video for another day. That is the historical and legal backdrop that brings us into the Google lawsuit. No. Actually, before we get into the Google lawsuit, I just need to read the description of Bill Gates' testimony in the context of that lawsuit. Bill Gates was called, quote, evasive and non-responsive, end quote, by a source present at his videotape deposition. He argued over the definitions of words such as, quote, compete, concerned, ask, and we. Certain portions of the proceedings would later provoke laughter from the judge when an exerted version was shown in court. Businessweek reported that, quote, early rounds of his deposition show him offering obfuscatory answers and saying, I don't recall, so many times that even the presiding judge had to chuckle. Many of the technology chief's denials and pleas of ignorance have been directly refuted by prosecutors with snippets of email Gates both sent and received, end quote.
Not recalling the specifics of the interview is that it's very unlikely I would make a statement like that without some common understanding between myself and the reporter of what that term, which out of context is incredibly ambiguous, what it meant in the context of her series of questions.
And just to be sure I understand it, what you're saying is that you don't remember what the definition was, and you don't even remember that there was a definition, but you believe there must have been a definition or you wouldn't have been using these words. Is that fair?
There must have been a common understanding. I wouldn't say a definition.
Now we can move on to the Google lawsuit. United States of America, State of Arkansas, State of Florida, State of Georgia, State of Indiana, Commonwealth of Kentucky, State of Louisiana, State of Mississippi, State of Missouri, State of Montana, State of South Carolina, and State of Texas. Plaintiffs versus Google LLC defendant. And just to open up a slight parenthesis, this is not even a purely partisan lawsuit. 3 of those plaintiff states are in fact Democrat governor states, so this is not a purely Republican or a purely Democrat issue. Complaint. The United States of America, acting under the direction of the Attorney General of the United States and the states of Arkansas, Florida, Georgia, Indiana, Kentucky, Louisiana, Mississippi, Missouri, Montana, South Carolina, and Texas, acting through their respective attorney generals, bring this action under Section 2 of the Sherman Act, 15 U.S.C. Section 2, to restrain Google LLC, Google, from unlawfully maintaining monopolies in the markets for general search services, search advertising, and general search text advertising in the United States through anti-competitive and exclusionary practices, and to remedy the effects of this conduct. What does Section 2 of the Sherman Act provide? Let's go see, shall we? 15 U.S.C. Code 2, monopolizing trade, a felony penalty. Every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among these several states or with foreign nations shall be deemed guilty of a felony and, on conviction thereof, shall be punished by fine not exceeding $100 million if a corporation, or if any other person, $1 million, or by imprisonment not exceeding 10 years, or by both said punishments in the discretion of the court. And just to answer a question that I noticed coming up in the comment section of my Netflix vlog, no, you cannot imprison a corporation, which is why if you don't see an individual defendant along with the corporation, you can pretty much write off prison time. Now, I'm just going to read the introductory paragraphs from the lawsuit itself before moving into the Department of Justice's executive summary, because those are the most essential allegations. Just to give you an idea, we don't need to get into the weeds of the 61-page lawsuit. And in any case, we are going to get into the weeds of the 61-page lawsuit in the 8-page executive summary. 2 decades ago, Google became the darling of Silicon Valley as a scrappy startup with an innovative way to search the emerging internet. That Google is long gone. The Google of today is a monopoly gatekeeper for the internet and one of the wealthiest companies on the planet, with a market value of $1 trillion and annual revenue exceeding $160 billion. For many years, Google has used anti-competitive tactics to maintain and extend its monopolies in the markets for general search activities such as advertising and general search text advertising, the cornerstone of its empire. As in many other businesses, a general search engine must find an effective path to consumers for it to be successful. Today, general search engines are distributed primarily on mobile devices, smartphones and tablets, and computers, desktops and laptops. These devices contain web browsers, software applications for accessing information on the internet, and other, quote, search access points that call on a general search engine to respond to a user's query. Over the last 10 years, internet searches on mobile devices have grown rapidly, eclipsing searches on computers and making mobile devices the most important avenue for search distribution in the United States. And this is the critical part when it comes to Google's Google's monopoly, and we're going to get into it a little more with the executive summary. For a general search engine, by far the most effective means of distribution is to be the present default general search engine for mobile and computer search access points. Even where users can change the default, they rarely do. This leaves the present default general search engine with a de facto exclusivity. As Google itself has recognized, this is particularly true on mobile devices where defaults are especially sticky. You're going to notice the concept of sticky coming up time and time again in the executive summary, in that even if something is not required, by virtue of the fact that it is the default setting, it becomes sticky in that most people never change it. And then we jump right into Google's antitrusty monopolistic behavior. For years, Google has entered into exclusionary agreements, including tying agreements, and engaged in anti-competitive conduct to lock up distribution channels and block rivals. Google pays billions of dollars each year to distributors, including popular device manufacturers such as Apple, LG, Motorola, and Samsung, major US wireless carriers such as AT&T, T-Mobile, and Verizon, and browser developers such as Mozilla, Opera, and UC Web to secure default status for its general search engine and, in many cases, to specifically prohibit Google's counterparties from dealing with Google's competitors. Some of these agreements also require distributors to take a bundle of Google apps, including its search app, and feature them on devices in prime positions where consumers are most likely to start their internet searches. Google's anti-competitive practices are especially pernicious because they deny rivals scale to compete effectively. General search services, search advertising, and general search text advertising require complex algorithms that are constantly learning which organic results and ads best respond to user queries. The volume, variety, and velocity of data accelerates the automated learning of search and search advertising algorithms. When asked to name Google's biggest strength in search, Google's former CEO explained, quote, "Scale is key. We just have so much scale in terms of the data we can bring to bear," end quote. By using distribution agreements to lock up scale for itself and deny it to others, Google unlawfully maintains its monopolies. The lawsuit goes on to allege that Google is effectively using the exact same monopolistic tactics as Microsoft, except they've gotten wise to avoid using certain type of monopolistic terminology to describe what they're doing. As far as Google's monopoly is concerned, the lawsuit and the executive summary, and for the rest of this vlog, I'm just going to use those two terms interchangeably, they conclude that Google has roughly 88% of the market share. It's had that 88% for a while, therefore it is a sustainable monopoly. General services search. For many years, Google has had a monopoly in general search services in the United States. Google's overall market share in general search is now 88%, and its monopoly has proven durable. Paragraph 92 of the lawsuit. The lawsuit goes on to allege that when it comes to mobile devices, Google's share is even greater, upwards of 94% of market share on mobile devices. And because these antitrust provisions were based on consumer protection, in theory there should be some injury to the consumer, and the lawsuit goes on to allege as much. Google's search monopoly has injured American consumers, quote, by restricting competition in general search services. Google's conduct has harmed consumers by reducing the quality of the general search services, including on dimensions such as privacy, data protection, and use of consumer data, lessening choice in general search services and impeding innovation. The lawsuit further alleges that because of the agreements Google has with other parties, some of these apps come pre-installed and cannot be removed, further exacerbating the injury to the consumer. Now, to give you an idea of Google's business model and the numbers at issue, let's get into Google's search advertising. Search ads enable advertisers to deliver targeted marketing messages in response to consumer queries in real time, which makes them highly valuable to advertisers. Paragraph 98. Google is a monopolist in the overall search ads market in the US, as well as the narrower market of text-based search ads, those that resemble organic links to websites on a general search engine's results page. In the US, advertisers pay about $40 billion annually to place ads on Google's search engine results page. Google's share of these search ads market is over 70%. Google's durable monopoly in search ads has harmed advertisers by enabling Google to collect higher payments and provide lower quality advertiser services than it would be able to in a competitive market. Paragraph 168. And the bottom line of Google's monopolistic conduct is that by virtue of its agreements that it enters into with the parties with whom it contracts, it effectively excludes any and all rivals from competing with it in the first place. By way of an example, let's look at Apple. Mobile distribution, Apple. Most searches, about 60%, are performed on mobile devices. Almost all mobile devices in the US use one of two operating systems. Apple's iOS, 60% of mobile device usage, or Android, 40%, which is developed by Google. Paragraph 43 of the lawsuit. Google pays billions of dollars to Apple each year to be the exclusive preset default general search engine for Apple's primary search access points, including including the Safari browser and Siri voice assistant. These payments make up about 15 to 20% of Apple's worldwide net income. Google can afford to pay Apple billions of dollars because they are only a fraction of the revenue that Google generates from search ads on Apple devices. More simply put, they have basically all of the revenue from online advertising, and they pay one of the two creators of operating systems a portion of their profits to ensure that they are the preset default on those operating systems. And the other operating system, Android, they own. Mobile distribution, Android. Android is open source, and this fact was critical to its rapid growth. A Google executive announced in 2010 that, quote, Android is poised for world domination, the success story of the decade, end quote. And it now accounts for over 70% of mobile device usage globally. Google's control over the Android ecosystem gives it additional levers that it uses to secure preferential and often exclusive distribution opportunities on Android devices. Google uses an interlocking set of contracts with Android device manufacturers and carriers to, quote, own the ecosystem, despite Android's open source code, and ensure that it is the dominant search provider on Android devices. Google also uses its power over Android to discourage the development of new and innovative mobile operating systems that might provide distribution to rival search engines. And then we have a graph detailing Google's exclusionary Android agreements. And from the lawsuit, just to summarily describe Google's distribution agreements. Google's distribution agreements come in three basic types, with the specific terms of each agreement depending on the counterparty and the search access points at issue. First, Google requires Android device manufacturers that want to pre-install Google's proprietary apps to sign an anti-forking agreement. These agreements set strict limits on the manufacturer's ability to sell Android devices that do not comply with Google's technical and design standards. Next, for Android device manufacturers that sign an anti-forking agreement, Google provides access to its vital proprietary apps and application program interfaces for pre-installation, but only if the manufacturers contractually agree to 1. Take a bundle of other Google apps, 2. Make certain apps undeletable, and 3. Give Google the most valuable and important real estate on the default home screen. Finally, Google provides a share of its search advertising revenue to Android device manufacturers, mobile phone carriers, competing browsers, and Apple. In exchange, Google becomes the preset default general search engine for the most important search access points on a computer or mobile device. As a practical matter, users rarely switch the preset default general search engine. In many cases, the agreements relating to mobile devices go even further, expressly prohibiting 1. The pre-installation of any rival general search services, and 2. The setting of other defaults to rival general search engines. This means that Google is the only preset default search provider pre-installed on the device. These agreements work exactly as Google designed them, to foreclose distribution to Google's search rivals, weakening them as competitive alternatives for consumers and advertisers by denying them scale. The lawsuit then goes on to detail exactly how Google has gotten so big that it is basically like a blob that keeps growing to the point where nothing can ever stop it. And it uses its size to ensure that nobody can ever compete with it. If a manufacturer wants to pre-install the Play Store and Google Play services and Android devices are not marketable without them, Google requires that the manufacturer pre-install a bundle of Google apps chosen by Google, covering important search access points like Chrome and Google Search app. Google requires some of these apps to be undeletable from the device regardless of whether consumers want them. Google also imposes placement requirements, including that its search widget is pre-installed on a device's home screen and that its voice assistant or search engine is the preset default when a user presses the home button. Finally, Google enters revenue sharing agreements that require distributors to make Google the preset default general search provider across all pre-installed search access points on an Android device. Quote, last year, Google paid major US carriers collectively more than $1 billion. As one Google executive explained, quote, our philosophy is that we are paying revenue share in return for exclusivity, end quote. Or as others might say, you have gotten so big and so powerful that you can prevent anybody else from entering the market, hence a monopoly. Absent a court order, Google will continue executing its anti-competitive strategy, crippling the competitive process, reducing consumer choice, and stifling innovation. Google is now the unchallenged gateway to the internet for billions of users. As a consequence, countless advertisers must pay a toll to Google's search advertising and general search text advertising monopolies. American consumers are forced to accept Google's policies, privacy practices, and use of personal data. And new companies with innovative business models cannot emerge from Google's long shadow. For the sake of American consumers, advertisers, and all companies now reliant on the internet economy, the time has come to stop Google's anti-competitive conduct and restore competition. And finally, the request for relief. To remedy these illegal acts, plaintiffs request that the court A. Adjudge and decree that Google acted unlawfully to maintain general search services, search advertising, and general search text advertising monopolies in violation of Section 2 of the Sherman Act. B. Enter structural relief as needed to cure any anti-competitive harm. C. Enjoin Google from continuing to engage in the anti-competitive practices described herein and from engaging in any other practices with the same purpose and effects as the challenged practices. D. Enter any other preliminary or permanent relief necessary and appropriate to restore competitive conditions in the markets affected by Google's unlawful conduct. E. Enter any additional relief the court finds just and proper. And F. Award each plaintiff an amount equal to its costs incurred in bringing this action on behalf of its citizens. That is the lawsuit, and you really realize the essence or raison d'etre, as we say in French, of the Sherman Antitrust Act is that companies can get so big they have all the revenue to do whatever they want to stifle any and all competition. They have become so powerful that they can maintain their own power. As a result of their power, it's sort of like a never-ending cycle. There is going to be the question as to what the consumer prejudice is, to the extent that these are free services being offered by Google, but they are free services being offered by Google because they're making so much money offering these services, collecting the data, that nobody else can compete with them. Anyhow, I hope that gives you a better idea of the lawsuit. Stay tuned for more follow-ups and certainly more discussion with Robert Barnes, because we will be discussing this lawsuit during our next live stream. It is absolutely fascinating, and the ramifications that it can have, serious. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because it feeds the algorithm.
You can do it, bellissimo.
If you want to support the channel, all of the support links are in the pinned comment. We've got PayPal, Patreon, Subscribe Star, YouTube membership. We've got merch, but more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah.